Redaction pattern. I'm holding page 47 of a document that took 8 years, 3 law firms, and one woman's testimony to unseal. And you still can't read most of it. 29 lines of sworn testimony blacked out. Not because the information doesn't exist, not because it was never given, but because someone with enough money and enough lawyers convinced a federal judge that you don't have the right to see it. Yet, my name is Sarah, and I've been an investigative journalist covering federal litigation in the Southern District of New York since 2012. I'm not a conspiracy theorist. I'm not here to sell you a theory about secret cabals or hidden codes. I'm here to walk you through what actually exists in the public record, what's still sealed, and why the gap between those two things has become a weapon all on its own. This stack on my desk? 2016 pages. Court documents from Giuffre versus Maxwell, released in waves between 2019 and 2024. Some pages are clean, some are half blacked out, and some, like page 47, are almost entirely redacted. Here's what keeps me up at night. I have 3 versions of some of these pages, same document, same testimony, but in the 2020 release, a name is redacted. In the 2023 release, it's visible. And in the 2024 release, redacted again. Not because new evidence emerged, but because someone filed an appeal and won. This isn't a story about Jeffrey Epstein. Not really. We know who he was. We know what he did. He's dead. This is a story about the architecture of silence, about what gets revealed, what stays hidden, and who gets to decide. Because after a decade of court battles, congressional inquiries, and FBI investigations, the Department of Justice issued a statement in January 2025 that was supposed to put the speculation to rest. It didn't. It made things stranger. Let me show you why. I first read Virginia Giuffre's name in April 2015. Not because I was investigating Epstein. I wasn't. I was covering civil cases in Manhattan federal court, mostly insurance fraud and contract disputes. Boring stuff. Her case popped up on the docket as Giuffre versus Maxwell. Defamation. I skimmed the filing summary and assumed it was another celebrity-adjacent lawsuit. Someone said something mean, someone suing for damages. I moved on. I was so fucking wrong. Defamation cases are interesting not because of the allegations, but because of the defense. If someone calls you a liar in public and you sue them for defamation, you have to prove you weren't lying, which means you have to document everything. You have to produce evidence, witnesses, timelines, corroboration. And if the person who called you a liar fights back, they have to prove you were lying, which means discovery, depositions, subpoenas. The case becomes a truth excavation, and everything that gets dug up goes into the court record. Ghislaine Maxwell called Virginia Giuffre a liar. She did it in public statements to the press. She said Giuffre fabricated stories about being trafficked, about being abused, about being introduced to powerful men by Jeffrey Epstein and Maxwell herself. So Giuffre sued. And to defend herself, to prove she was telling the truth, her legal team went to work. They subpoenaed flight logs, they deposed household staff, pilots, assistants. They collected photographs, phone records, emails. They interviewed other women. By the time the case settled in 2017, the docket listed 167 sealed exhibits. Maxwell paid Giuffre an undisclosed sum. The case closed. But here's the thing. Most people don't understand about sealed court documents. They don't disappear. They stay in the court's possession. They're under a protective order, meaning they're not public, but they exist. They're in a vault, legally speaking. And under federal law, the public and the press have a presumptive right to access judicial records unless there's a compelling reason to keep them sealed. So in 2018, a group of media organizations, the Miami Herald, the New York Times, and others, filed motions to intervene. They petitioned the court to unseal the Giuffre Maxwell documents. They argued there was significant public interest. Judge Loretta Preska, who inherited the case, agreed to review the materials. But she didn't just unseal everything. She went page by page, name by name, balancing transparency against privacy. And she allowed the people named in those documents, people who weren't parties to the lawsuit, to file objections, to argue why their names should stay redacted. That's when it got complicated. July 2019. Jeffrey Epstein is arrested in New Jersey on federal sex trafficking charges. The story explodes. Suddenly, everyone wants to know who was in his orbit, who knew, who participated. And those sealed documents from the Maxwell case, still under review, become the most sought-after files in federal court. Judge Preska orders the first wave of unsealing. Hundreds of pages go public, but they're heavily redacted. The names of alleged victims are protected, which makes sense. But so are the names of dozens of other people listed as John Doe 1, John Doe 2, all the way up to John Doe 200-something. Some of those does were famous, some weren't. Some were accused of crimes, some were just mentioned in passing, and each one had the right to file a motion to stay redacted. August 2019. Epstein dies in his cell at the Metropolitan Correctional Center, ruled a suicide. The criminal case against him dies with him. But the unsealing process continues. Because this isn't a criminal case, it's a civil matter. The documents aren't evidence in a prosecution. They're records of a lawsuit. And the public's right to access them doesn't depend on whether Epstein is alive. 2020. Second wave of documents, more pages, fewer redactions. We start seeing names. Alan Dershowitz, Epstein's former lawyer, is named by Giuffre in her testimony. He denies everything. He's never been charged. He sues Giuffre for defamation. She countersues. That case is still ongoing. Glenn Dubin, a hedge fund billionaire, is named in depositions by one of Epstein's household staff. He denies any wrongdoing. He's never been charged. Jean-Luc Brunel, a modeling agent, is named by multiple women. He's arrested in Paris in 2020. He dies in his cell in 2022. Another suicide. And here's where it gets strange. By 2023, some of the John Does have exhausted their appeals. Judge Preska rules their names can be unsealed. And we get another batch of documents. I download them the day they drop. I pull up page 47, the one I showed you earlier, and I compare it to the version I saved from 2020. 3 years ago, line 14 was redacted. Now it says a name. I can't tell you the name here, not because it's still sealed, but because even though it was unsealed in 2023, that person's lawyers filed an emergency appeal in early 2024 and got it re-redacted pending further review. You see the problem? The same testimony, the same words, the same piece of information, public, then private, then public, then private again. Not because the facts changed, but because the legal fight never stopped. Now, let me explain something that trips everyone up, including journalists who should know better. There is no single Epstein client list. That phrase gets thrown around like it's a real document sitting in a filing cabinet somewhere. It's not. What exists are 3 overlapping, often confused categories of information. Category 1, flight logs. These have been public since 2016. A pilot who worked for Epstein kept detailed records of passengers on Epstein's private planes. Those logs were subpoenaed in earlier lawsuits and released through FOIA requests. They list names, dates, routes. Bill Clinton is in those logs. He flew on Epstein's plane multiple times in the early 2000s, mostly to Africa for Clinton Foundation events. He's never been accused by any victim of abuse. Kevin Spacey is in the logs. Chris Tucker, Naomi Campbell. Being on the plane doesn't mean you did anything criminal. It means you were on the plane. Category 2. People named in the Giuffre depositions and other victim testimony. This is a broader list. Some of these people are accused of abuse. Some are witnesses. Some are people Giuffre mentioned meeting at a party once. Prince Andrew is in this category. Giuffre accused him directly. He denied it. He settled a civil suit with her in 2022 for an estimated $12 to $15 million. Settlement is not admission of guilt, but it's also not exoneration. He's never been criminally charged. Marvin Minsky, the legendary AI researcher from MIT, is named by Giuffre. She testified that Epstein told her to have sex with Minsky. Minsky's colleagues and family have said he turned her down. He died in 2016. There's no way to test the allegation in court. It just sits there in the transcript, unresolved. Category 3, people who have been charged or convicted. This is the smallest group. Ghislaine Maxwell, convicted in 2021 on 5 counts of sex trafficking. She's serving 20 years. Jean-Luc Brunel, charged in France, died before trial. And Epstein himself. That's it. That's the list of people who faced criminal consequences in connection with this case. The public conflates all 3 categories. They think flight log means criminal. They think named in testimony means guilty. And they think there's some 4th category, a secret ledger of powerful people Epstein had dirt on, that's being hidden by the government. That last part is where things get interesting. January 14th, 2025. The Department of Justice issues a statement. It's in response to FOIA requests, congressional inquiries, and years of public pressure. The statement says, quote, "Contrary to public speculation, the FBI's investigation found no evidence of a centralized blackmail list or client ledger maintained by Jeffrey Epstein." I read it 3 times. Not because I didn't believe it, but because of what it implied. The DOJ is technically correct. There is no document labeled blackmail list, no spreadsheet called compromat.xlsx. But let's talk about what they didn't say. They didn't say Epstein didn't use his relationships as leverage. They didn't say he didn't collect information. They didn't say the investigation found nothing. They said there's no centralized list, which is a very specific denial. Here's what the FBI did find, according to public records and reporting. When they raided Epstein's Manhattan townhouse in 2019, they recovered computers, hard drives, CDs, and a safe. The inventory list was released. The contents of those drives and CDs were not. In Epstein's Palm Beach house, investigators found a massage room with a cabinet full of sex toys and a bookshelf of photo albums. Some of those photos were of underage girls. Those images became evidence in the 2008 case and the 2019 case. But not all of the material seized has been made public. Multiple victims, in their depositions, describe Epstein asking them questions, personal questions, about themselves, about their families, about the men they met through him. What did those men like? What did they say? One victim, in her testimony, says Epstein once told her he needed to keep someone happy and asked her to have sex with that person. The name is redacted. The context is clear. Another deposition, this one from a woman named Johanna Schoberg, describes being at Epstein's New York house and meeting a famous man. The man is not accused of assault in her testimony, but she describes Epstein encouraging her to sit on this man's lap for a photo. She says Epstein liked to create situations, to test boundaries, to see what people would do. That's not a blackmail list. That's a social architect creating leverage in real time. The most chilling detail, for me, is in testimony from one of Epstein's housekeepers. She describes cameras in the bedrooms, cameras in the bathrooms, cameras disguised as smoke detectors. The FBI confirmed finding recording equipment during their raid. Who was recorded? When? What happened to those recordings? The DOJ has never said. So when they say there's no centralized list, I believe them. But absence of a list doesn't mean absence of leverage. Epstein's power wasn't a Rolodex. It was relational. It was transactional. It was implicit. You don't need to write down someone's secrets if they know you have them. I attended Ghislaine Maxwell's trial in December 2021. I sat in the overflow room at the courthouse in Lower Manhattan, watching the proceedings on a monitor. The prosecution's case was airtight. They called 4 victims. They showed flight logs, phone records, photographs. They proved Maxwell recruited girls, groomed them, and participated in their abuse. The defense tried to argue she was a scapegoat, that Epstein manipulated her too. The jury didn't buy it. Guilty on 5 of 6 counts. But here's what didn't happen at that trial. The prosecution didn't call several witnesses who were listed in pretrial documents. They didn't introduce certain depositions that had been taken in the civil cases. Why? Because they didn't need to. They had enough evidence to convict Maxwell without opening up a broader web of implications. Strategic choice, smart, from a prosecutorial standpoint, but it meant that names, allegations, and connections that existed in those depositions were never tested under oath in a criminal trial. They stayed in the civil record, sealed or redacted, and some of those witnesses had immunity. In 2008, when Epstein cut his sweetheart plea deal with federal prosecutors in Florida, his legal team negotiated immunity for potential co-conspirators. That immunity, granted by then U.S. Attorney Alex Acosta, still stands, which means some people who were involved, who were named, who could have been charged, can't be touched. That immunity agreement is public record. The names covered by it are not. Let me take you outside the United States for a moment, because this story isn't just American. In France, authorities opened their own investigation into Epstein's activities in Paris. Jean-Luc Brunel, the modeling scout, was arrested at Charles de Gaulle Airport in December 2020 as he was trying to board a plane to Senegal. He was charged with rape of minors and human trafficking. He was held without bail. In February 2022, he was found hanged in his cell. Prison officials ruled it a suicide. His case files, under French law, remain sealed. In the UK, Prince Andrew's legal team fought to keep Giuffre's lawsuit out of British courts. They failed. He settled before deposition. The terms of that settlement are confidential, but reporting suggests it was between $12 and $15 million. The British press published details about Andrew's relationship with Epstein that American outlets couldn't, because UK libel law works differently. So, there's a strange asymmetry. Some things you can read about Andrew in The Guardian that are still redacted in US court documents, and vice versa. There are also investigations in the US Virgin Islands, where Epstein owned Little St. James Island. The local government sued his estate in 2020, alleging his operation there violated trafficking laws and corrupted local officials. That case settled in 2022 for $105 million, but the settlement included sealing certain documents. What's in those files? We don't know. The government got paid, the estate closed, the secret stayed buried. Here's where my understanding of this entire story changed. It wasn't a document that did it. It wasn't a bombshell revelation, it was a conversation. In 2023, I spoke off the record with a lawyer who represented one of the John Does in the unsealing process. I can't tell you which Doe or which lawyer, but I can tell you what he said. I asked him why his client fought so hard to stay redacted. Why spend years and presumably hundreds of thousands of dollars in legal fees to keep your name out of documents that most people will never read? He said, because being named in the same document as Epstein destroys you, even if you did nothing wrong. My client flew on the plane once. He's in the logs. One flight, 10 years ago, for a business meeting. He never went to the island. Never met a victim, but his name is in there. And the day it went public, he was doxxed. His business partners dropped him. He got death threats. His daughter was harassed at school. The internet doesn't care about context. The list is the weapon. That stuck with me. Because he's right. The mechanism that's supposed to protect witnesses, to prevent collateral damage, to distinguish between the guilty and the incidental, that same mechanism protects people who do have something to hide. Redaction becomes a shield for everyone, and we can't tell who's hiding behind it legitimately and who's just rich enough to afford the appeal. The system can't differentiate, so it over-redacts, and in doing so, it creates the very opacity that fuels conspiracy. Let me be precise about what we don't have. What's still missing? Because this is where the frustration lives for anyone who's actually tried to follow this story with rigor. 1. Financial records, post-2008, Epstein's bank accounts, his transactions, his business dealings after his first conviction. Those are not public. We know he had money, we know he paid settlements, we know he funded scientific research and donated to politicians. But the detailed financial trail, sealed or never subpoenaed. And here's what makes that particularly strange. Epstein's wealth has always been murky. He claimed to manage money for billionaires, but only one client was ever confirmed. Leslie Wexner, the founder of Victoria's Secret. Wexner gave Epstein power of attorney over his finances in 1991. That's an extraordinary level of trust. When Epstein died, Wexner's lawyers said he'd severed ties in 2007 and that Epstein had misappropriated millions. But the details? Never made public. Where did the rest of Epstein's money come from? How did he maintain properties worth over $100 million? The estate filings show assets, but not the source. Follow the money is the oldest rule in investigative journalism, and in this case, we can't. 2. The contents of the safes. The FBI released an inventory of what they took from Epstein's properties. The inventory lists compact discs, hard drives, photographs, and documents. It does not describe what's on those CDs or drives. Some became evidence in the Maxwell trial. The rest, we don't know. And here's what bothers me about that. In digital forensics, you can examine a hard drive and catalog every file without releasing it publicly. The FBI has done this. They've seen what's there. But they've never said whether those drives contained correspondence, financial records, or recordings. In 2019, federal prosecutors told the judge they'd found vast troves of images. Some were introduced as evidence. Were there videos? The housekeeper testified there were cameras. Where are the recordings? Were they destroyed? Still classified as evidence? Or do they not exist? The silence around this is deafening. 3. The 2008 grand jury testimony. When Epstein was first investigated in Florida, a grand jury heard evidence. That testimony has been sealed for 17 years. In 2024, a Florida judge ruled that the transcripts could be released, but set no timeline. As of today, they're still sealed. What did those witnesses say? Who did they name? We're waiting. And here's why this matters more than people realize. The 2008 case was the first time Epstein faced serious legal jeopardy. Detectives in Palm Beach had interviewed multiple victims. They'd executed search warrants. They'd collected physical evidence. The case was strong enough that the state prosecutor wanted to charge Epstein with multiple counts of unlawful sex with a minor. Then, the feds stepped in. They took over the case, and suddenly the charges disappeared. The grand jury was convened, heard testimony, and then Epstein got his plea deal. What happened in that room? What did the jurors hear that made them return whatever indictment they returned before it was all negotiated away? Those transcripts are the missing link between the local investigation and the federal deal, and they're still locked. 4. Communications between Epstein and certain public figures. Deposition reference emails, text messages, phone calls. Some are entered as exhibits. Most are just cited. Epstein sent an email to Redacted on March 4, 2015, arranging a meeting in Paris. The email exists. It's referenced in court filings, but it's not in the public exhibits. Why mention it if you're not going to show it? Because it provides context for testimony. But that context is incomplete without the actual message. In one deposition, a victim describes Epstein showing her his phone and scrolling through text messages from famous people. She names some of them. The deposition notes that Epstein was showing off his connections, making her feel like he was untouchable. But the actual messages, never subpoenaed, or if they were, never released. And with Epstein dead, his phones are in government custody. What's on them? We don't know. 5. The full scope of the 2019 FBI raid. We have the inventory list. We know what categories of items were taken, but we don't have the FBI's internal reports about what they found. Under normal circumstances, after a criminal case concludes, some investigative files can be released through FOIA. But the Epstein case didn't conclude normally. It ended with his death. The DOJ has said the investigation is closed, but they haven't released the case files. They haven't released the forensic reports. They haven't released the interview transcripts with potential witnesses who were never called to testify. All of that is still internal, and every FOIA request gets the same response. Ongoing law enforcement concerns, privacy exemptions, or simply no records found. The reason this documentary exists is because every institution failed. I'm not speaking hyperbolically. I mean every single one. In 2008, federal prosecutors in Miami had evidence to charge Epstein with sex trafficking. They had victim testimony. They had witnesses. Instead, they offered him a plea deal. 13 months in county jail with work release during the day. He served his time in a private wing of the Palm Beach stockade. He was allowed to leave 6 days a week to go to his office. The deal also granted immunity to 4 named co-conspirators and any other potential co-conspirators. It was one of the most lenient plea agreements in the history of federal sex crime prosecution. Alex Acosta, the U.S. attorney who approved that deal, later became Secretary of Labor under Trump. He resigned in 2019 after the Epstein case reopened. In his resignation statement, he said he was told Epstein belonged to intelligence and to leave it alone. He later walked that back, saying he was referring to Epstein's lawyers claiming connections, not that he had proof. But the damage was done. The phrase belonged to intelligence became a meme. And we still don't have a clear answer about what that actually meant. Was it bluster from Epstein's lawyers? Was there an actual connection? Acosta has never fully explained. The plea deal violated federal law. The Crime Victims' Rights Act requires prosecutors to notify victims of plea agreements. Acosta's office didn't. In 2019, a federal judge ruled that the deal was illegal. But it wasn't voided. Epstein was dead by then. The immunity grants still stand. The FBI had open investigations into Epstein in 2016. Multiple field offices were aware of allegations. But no charges came until 2019, after the Miami Herald published Julie K. Brown's investigative series, Perversions of Justice. That series, based on interviews with dozens of victims and a review of court records, put public pressure on the DOJ weeks later. Epstein was arrested. The FBI didn't move until the press forced them to. And then there's the Bureau of Prisons. Epstein was held at the Metropolitan Correctional Center, one of the most secure federal detention facilities in the country. He was on suicide watch after an apparent attempt in July. Then he was taken off suicide watch. His cellmate was removed. The cameras outside his cell malfunctioned. The guards didn't do their required checks. On August 10th, 2019, he was found dead. The medical examiner ruled it suicide by hanging. An independent pathologist hired by Epstein's family said the injuries were more consistent with strangulation. The DOJ's Inspector General found serious irregularities, but no evidence of foul play. I'm not here to tell you Epstein was murdered. I'm here to tell you that the facility failed so badly that we can't rule it out. And that's almost worse. Because even if it was suicide, the fact that he was able to kill himself while supposedly under watch means the system collapsed. And if it wasn't suicide, that means something even darker. Either way, the institution failed. This is what institutional failure looks like. Not a conspiracy, just cowardice, incompetence, and a system that bends toward protecting power. Let's go back to that DOJ statement from January 2025. No centralized blackmail list. They're trying to kill the speculation, to tell the public. Stop looking for a document that doesn't exist. But here's what they're not saying. They're not saying Epstein didn't leverage relationships. They're not saying all evidence has been collected. They're not saying every lead was pursued. They're saying we didn't find a list, as if that's what we should have been looking for. The absence of a smoking gun doesn't mean absence of smoke. It means the fire was already burning when we got there, and by the time we arrived, all that's left is ash. Here's what is documented, what you can verify yourself if you go to the PACER database and pull the case files. Testimony from Johannes Sjoberg, 2016 deposition, page 39. Epstein told me he needed to keep name redacted happy because redacted. Testimony from Virginia Giuffre, 2016, page 274. I was instructed to have sex with redacted. This took place at redacted. Testimony from a household employee, name sealed, describing cameras in the New York residence. There were cameras in places you wouldn't expect. I was told not to ask about them. Alan Dershowitz is named by Giuffre. He has categorically denied her allegations. He has never been charged. He has written op-eds, appeared on television, and filed multiple defamation suits defending himself. That's public record. Glenn Dubin is named in testimony by a former employee who says a young woman came to her in distress at Dubin's home. Dubin denies the allegations. He's never been charged. Marvin Minsky, the MIT scientist, is named by Giuffre. His widow and colleagues have said he declined Giuffre's offer. He died before he could testify. The allegation sits there, unresolved. These are real allegations. real denials, and no criminal court has tested any of them. That's the gap. That's the void. And into that void, people pour speculation. The global dimension of this is important. This wasn't just an American operation. Epstein had homes in New York, Florida, New Mexico, Paris, and the Virgin Islands. He moved in international circles. Jean-Luc Brunel's modeling agency, MC2, operated in the US and Europe. Some of the victims were recruited in Eastern Europe, South America, and the US. The trafficking was transnational, which means different jurisdictions, different legal standards, different sealing rules. A name that's redacted in a US court filing might be public in a French tabloid. Evidence collected in the Virgin Islands might be sealed under local law, even though it's connected to a federal case. The result is a patchwork of disclosure. You can see part of the picture in one country, another part somewhere else, but never the whole thing at once. Prince Andrew's case is the perfect example. In the US, his name appears in unsealed depositions. In the UK, the tabloids published allegations years before American outlets did, but under different legal constraints. His settlement with Giuffre is confidential, but both sides confirmed it happened. What did he admit to in that settlement? We don't know. The agreement itself is sealed, but the fact of the settlement is public, so we know something happened. We just don't know what. And let me tell you what that settlement process looked like from the outside, because it's instructive. Andrew's lawyers tried every procedural maneuver to get the case dismissed. They argued Giuffre wasn't a U.S. resident and couldn't sue in U.S. court. They argued the case should be sealed entirely. They argued that a prior settlement Giuffre had reached with Epstein's estate released Andrew from liability. Judge Lewis Kaplan, who handled the case, rejected every motion. He scheduled a deposition. Andrew would have to sit in a room under oath and answer questions about the allegations, about his relationship with Epstein, about the photograph of him with his arm around 17-year-old Virginia Giuffre, with Ghislaine Maxwell standing in the background. That photograph is public. Andrew's lawyers have questioned its authenticity, but it exists. Days before the deposition, Andrew settled. No admission of wrongdoing, no details, just a payment and a joint statement saying the matter was resolved. And that's how it ends for people with resources, not with truth, with money. Here's what haunts me, not what's in the redactions, but what was never written down at all. The meetings that weren't logged, the flights that weren't recorded, the victims who never came forward, the men who were careful. Epstein kept the people around him close, but he kept his real secrets closer, and those weren't written down. I started this video by showing you page 47. 47 lines of testimony, 29 of them blacked out. Judge Preska is still reviewing appeals. In 6 months, maybe a year, some of those names will be unsealed. Maybe all of them. Or maybe none. The legal fight continues. The does keep filing motions. The press keeps intervening. And the public keeps waiting for a revelation that may never come in the form they expect. Because here's the unsatisfying truth. Most of the names in those documents, you already know them. They've been public for years. They've been reported, denied, litigated. The ones still redacted. Some are victims, some are witnesses, some are incidental, and some are rich men with expensive lawyers. We can't know which is which unless the process finishes. And it might take another decade. The cost of not knowing isn't just frustration. It's corrosive. In the absence of facts, people fill the void with suspicion. They create lists that don't exist. They accuse people who were never named. They treat redaction itself as proof of guilt. And that's dangerous. Not because the powerful don't deserve scrutiny. They do. But because a system that can't distinguish between the guilty and the incidental eventually loses the ability to deliver justice at all. I understand the impulse, though. I do. Because the system did fail. Epstein did evade accountability for decades. Powerful people were protected, just not in the way the memes suggest. It wasn't a conspiracy. It was something more banal and more terrible, a series of institutions that chose the path of least resistance. Prosecutors who took the easy plea, agents who didn't follow up, guards who didn't do their checks, lawyers who knew how to exploit every procedural delay, and a legal system that lets money buy time and time buy silence. The Epstein case isn't an aberration, it's a stress test, and we failed it. So when people ask me, where's the list? I tell them there are 3 lists. One is public, one is partial, and one never existed the way you think it did. What exists is 2,000 pages of testimony, some of it readable, some of it redacted, all of it fought over by lawyers who bill by the hour. What exists is a pile of evidence that proved one thing, conclusively. Jeffrey Epstein and Ghislaine Maxwell trafficked children. She's in prison, he's dead. And everyone else is in the margins, footnoted, redacted, or denied. The questions that remain aren't about a secret list. They're about why it took so long, why the plea deal happened, why the FBI waited, why the cameras failed, why no one else has been charged. Those are harder questions because the answers aren't hidden in a vault. They're in budget memos and staffing decisions and risk assessments. They're in the boring machinery of institutional failure. And that doesn't make for a good conspiracy theory, but it's the truth. I'm going to keep covering this. I'm going to keep downloading the unsealed documents every time a new batch drops. I'm going to keep comparing redactions, tracking appeals, and reading the footnotes. Because that's where the story is. Not in the fantasy of a hidden ledger, but in the tedious, infuriating reality of a justice system that moves slowly, bends toward power, and sometimes just stops. And maybe that's the real scandal. Not what we don't know, but what we do know and how little it's changed. Page 47 is still mostly blacked out, but I'll keep looking at it. Because one day, those bars might lift, and when they do, I'll tell you what's underneath. Not because it'll be shocking, but because it'll be true. And in a story this polluted with speculation, truth is the only thing worth fighting for. That's it. That's the video. No dramatic reveal, no bombshell. Just the slow, grinding work of watching a broken system try to correct itself, or fail to. We'll see which. I'll be here either way.